Start. Heard. Mr. Korgev, learned advocate for petitioner, and Mr. Patil, learned advocate for respondent. Para. Present writ petition takes exception to the judgment and order dated 13/10/2023, passed by the Learned District Court in MCA number 206/2023, upsetting the order dated 22nd/6/2023, passed by the Learned Trial Court in Exhibit 5 proceedings. Para. Briefly stated, some basic facts need to be narrated before I advert to the pleadings in the plaint and the case of the plaintiff who is before me. Respondent is aggrieved due to stay granted by this court on the impugned order. Para. Dispute between parties pertains to an area measuring 1.83 r out of gut number 189 and construction being carried out on the said suit property by the defendant. Admittedly, gut number 189 belonged to Dattatray Gangaram Patil, who expired on 25/8/1979. As per revenue record, he was survived by his wife Hirabai, one son Dhanaji, and 6 daughters, namely Gaurabai, Draupadi, Sakhubai, Indubai, Malubai, and Nakusha. At this stage, Mr. Patil has drawn my attention to page number 86 of the writ petition and would submit that the suit property originally stood in the name of Sadappa, brother of Dattatray, and Anubai, his wife. On their demise, the said gut number was recorded and mutated in the name of Dattatray Patil. Hirabai expired on 22nd/2016, whereas Dhanaji predeceased her on 25th/10/2015. Dhanaji Patil is survived by his son Harshvardhan, who is the petitioner, and 2 daughters. Curiously, plaintiff filed the suit on the premise that his claim is in respect of ancestral property belonging to Dattatray Patil, without even impleading his own sisters as also the other legal heirs, which would be otherwise be entitled to under the 6 sisters of Dhanaji. Para. Defendant's case is that he is in possession of the suit property on the basis of an unregistered sale deed, which is denied by the plaintiff. Defendant claimed that this sale deed dated 14th/8/1993 was executed between Hirabai and Tanaji Patil, father of the defendant, pursuant to which Tanaji was put in possession of the suit property, and defendant's family has been enjoying the same since 30 years without any hindrance. Para. Case in the suit plaint filed in the year 2023 by the plaintiff is on the basis that plaintiff was having his own RCC old house on the suit property wherein he was storing his agricultural equipments and movable properties. Plaintiff has averred that he stopped using the said house since it was old and dilapidated, and it is only in the year 2023 for the first time he found that defendant had started construction on the suit property, which had reached up to the plinth level, after which the suit was filed claiming injunction against the defendant and possession of the suit property. It is thus seen that if the suit is filed for possession of the suit property, then it should only have been on the basis of the plaintiff having lost possession of the suit property to the defendant. In that regard, issue of possession, both the courts below, trial court and district court, have categorically acknowledged that the possession of the suit property is with the defendant. Whether and how the defendant has perfected his title would ultimately depend upon the evidence in the suit laid by him, since the suit is not filed for title but only for injunction and possession by the plaintiff. There is additional evidence which has been delineated in both the orders passed by the courts below, which prima facie show that the plaintiff was in possession of the suit property since long, either himself or through his father Tanaji. The question then that would arise in such case is whether did the defendant dispossess the plaintiff. But on reading the suit plaint, there is not an iota of material evidence produced by the plaintiff. The case of the plaintiff that 8 days before filing the suit,